Now, Mark, what's your assessment of the court's opinion?
Don, the Supreme Court spoke with a unanimous voice here. It said effectively that a state does not get to bounce a candidate from the presidential ballot that would invite a patchwork of decisions across the country and would frustrate the intent of the voting for our president. And as I said, that was a unanimous decision. It was 5-4 in the sense that 4 of the justices only concurred in the result and, of course, concurred in some of the decision in the majority opinion. But at the end of the day, it was 9-0 that states like Colorado or Maine or even Illinois don't get to decide that the president is not going to be nominated, that a candidate for president is not going to be nominated.
And I want to point this out as well. The Supreme Court's opinion doesn't address whether Trump's actions on January 6th actually qualified as an insurrection or not. So why do you think the court took the route they did with this ruling?
I think, Don, the way they took this ruling was they wanted to be unanimous. And so they intentionally avoided addressing whether President Trump, former President Trump, was an oath-breaking insurrectionist, which is the way Justice Sotomayor, Jackson, and Kagan referred to somebody who would be bounced from the ballot under Section 3 of the 14th Amendment. They didn't want to address it, probably because all the justices don't agree on that point. I'm just speculating, but I think it's a reasonable speculation, as opposed to the fact that they all agree that one state can't remove a presidential candidate from the ballot, because then that would be one state making a decision for the whole country.
So, Mark, while this opinion was unanimous, Justices Barrett, Sotomayor, Kagan, and Jackson did express disagreement about whether the court needed to go as far as it did in this ruling. So explain that for us.
Well, Don, I find it interesting and perhaps meaningful that it's a breakdown of 5 men on one side and the 4 women on the other side. And what the 4 women said was that to the majority, they said, we don't have to decide anything more than the fact that Colorado doesn't get to make this decision, that it's Congress that makes the decision as to who's going to be on the ballot. But in fact, the opinion went further. The 5 justices went so far as to say that Congress would have to pass a law to decide whether or not an oath-breaking insurrectionist can be on the ballot or not. And so the 4 women said, we don't have to answer that question. In a sense, it reminds me, and perhaps I'm being a little bit humorous here, of the idea that sometimes men want to solve all the problems, and the women say, well, I don't want you to solve every problem, just the problem I put before you. In any event, that's what happened here. The 4 women do not like how far the 5 justices went on the other side.
So looking ahead, what could be the future impacts of this ruling on these additional questions?
Well, there's absolutely no question. This will be a decision that is studied for years and years, for decades. We certainly look at Bush versus Gore, 24 years on. The justices who concurred, Kagan, Sotomayor, and Jackson, went out of their way to make sure that even though they agreed in the result and they were clear on that this is a unanimous decision, they wanted the history books to reflect that they cited Dobbs and Bush versus Gore in expressing their displeasure with how far the opinion went. They did that not just for themselves, but also for history. This is going to have a decision that will impact the country for as long as it survives.
Now, Mark, I don't know if you found this interesting, but actually legal experts have noted that the ruling on this case came out unusually fast. Do you think there's a reason behind that? Why do you think that is?
I think the justices, all of them, want the law to be kept separate from politics. And the more that Supreme Court has to get involved in these sort of political fights, which is really what this case was about, keeping somebody off the ballot, is a presidential attack, is a political attack on party versus party. It's not really a legal question. The fact that it was 9-0 to me suggests it wasn't so much a difficult legal question, because all 9 justices agreed left to right of the political aisle. And so what they're saying by deciding it quickly is, look, let the people decide who they're going to vote on, or Congress can get involved on a political question, but it shouldn't be up to the justices as to who's going to be president. And they don't want to see another Bush versus Gore.
And as well, Mark, I want to ask you a very fundamental question. How significant is this ruling for the Constitution and foundation of American democracy?
This is absolutely, Don, very significant. There's been very few cases that interpreted Section 3 of the 14th Amendment. In fact, the oral argument reflected as much. The justices, for the most part, were relying upon comments made during the passage of the 14th Amendment or cases that were discussed this part of the 14th Amendment, but not cases where the Supreme Court was addressing it, but just one judge or one justice. And so this is the first time that the Supreme Court is really having to make a decision of such profound importance, and it will affect all the presidential elections to come.
And maybe you can comment on this as well for our viewers. So we had an unanimous decision. So how much of a pivotal moment was this ruling for the court?
Well, I think it's important for the court because it gets at the idea that the court is not a political institution. Both on the left and the right, there tends to be an emphasis that the court is just made up of justices who are appointed by a certain political party and that they just make decisions based on their political allegiance. And that's not true. If you believe in the rule of law, which I do, these justices are trying to follow the rule of law and not follow and just support whoever appointed them. And by deciding this decision 9-0, the justices are sending that message that this is not a political decision, this is a question of the rule of law.
And Mark, finally, what, if anything, does this ruling and its speed tell us about what we can expect for the Supreme Court's ruling on Trump's other Trump presidential immunity case?
Well, we have that important immunity case that was just recently granted. They're going to hear argument on that case the week of April 22nd. If they follow the practice they followed here, you could see a decision in that case within a month of April 22nd. That would be late May. I think the bottom line implication of this decision and how quickly it was made is that the court does not want to be involved in deciding who is the next president of the United States. They want that to be left to the voters and, to the extent that the 14th Amendment says so, up to Congress as well.
All right. Thank you very much, Mark, for your time today.
Thank you.